And we were moving on to the rights that the mortgager and the mortgagee have. These are the equitable rights that the mortgagee and the mortgager have. Now, we talked about a few cases. We talked about different types of mortgages, and we said we look at a few cases. Who had the time to look at the cases on how mortgages can be created? So on the nature of a mortgage, remember we got the definition from the case of Santley versus Wild, 1899 CH474. Who had the chance to look at this case? Okay, you still have a task to look at the case of Santley versus Wild so that you know, understand in detail the nature of a mortgage. And we also looked at the case of, we talked about it. I said you go and look at it. When we're looking at creation of an equitable mortgage, where a need arises for a caveat to be put on land to protect one's interest in land. The case of Magic Carpet Travel and Tours Limited versus Zambia National Commercial Bank Limited, 1999, ZRR 61. Did we have a chance to look at this case? Can anybody give us the brief facts and the holding of Magic Carpet Travel and Tours Limited versus Zambia National Commercial Bank Limited? Someone is thinking about giving us details, brief details. Also, look at the case of under the depositing of title deeds to create an equitable mortgage. Look at the case of Mbilishi and another. Mbilishi and another. Mbilishi is MBILISHI, Mbilishi and another versus Tire King Enterprises Limited versus Tire King Enterprises Limited. Supreme Court, Appeal number 13203. Supreme Court, Appeal number 13203. Is anyone ready to give us the case of the facts of the case of Magic Carpet Travel and Tours Limited versus Zambia National Commercial Bank Limited? As you are thinking about it, anything that you want to talk about before we go on? Read the cases. Read the cases. Understand what the case is about. Understand what, for which case. I don't know if Lexina Rain is your real name or it's a pseudonym. Which case are you asking about? Lelo, anything to say? Lelo. Okay. Let's look at the rights of the mortgager and the mortgagee. What rights do they have? Okay, Lexina is back. And I said, I don't know if it's your name or not. What's your name and which case are you asking about? You want the full citation for which case?
Good morning, ma'am.
Morning.
For the Mbilishi and that case, I didn't get the full citation.
Okay, let's share the full citation. Who got the case or the details of the case? What's the full citation? Anybody?
If I'm not mistaken, it's Bilishi and another Mrs. Tire King Enterprises Limited, Supreme Court Appeal number 12303.
Yes, appeal number 13203. 132/03. I hope you got what Lelo has said, Lexina. Lexina, are we on the same page? Okay, thank you. So, did we go through the magic carpet case? That's my interest right now. Okay, so when you look at the Mbilishi case, it demonstrates the fact that it is tried law that if one deposits their title deeds, an equitable mortgage is created. So you don't need any evidence more than that. As long as the record shows that the title deeds were deposited with the lands and deeds registry, the title deeds were deposited with your potential lender, that's it. So it gives you like reaffirmation or demonstrates how the law works. This is why we are saying it is tried law that a deposit of title deeds results in what? A mortgage being created. So when you look at the case of Magic Carpet Travel and Tours Limited versus Zambia National Commercial Bank, I gave you this case deliberately last week for you to go and have a look at it and we discuss it somehow. Did anybody do that? We are talking about a need for a caveat so that there is, like, one's interest in land is protected. So this is where the magic carpet case comes in, where if an equitable mortgage is created with a third party, and then in an event that the third party, just following the facts of magic carpet, in an event that a third party obtains a duplicate certificate of title in a fraudulent way, usually what happens is that parties who want to protect their rights will go on and once they show their title at the ministry through the registrar's office, they will, when we talk about the registrar, we're talking about the Lands and Deeds Registry, we see that they will want a caveat to be put on the land for the protection of that particular property. And usually when there's that intention to become a mortgagee, that step should be taken. So these are the facts that you see similar coming out in the case of magic carpets. I need somebody to chip in and say something about it. Anybody? Anyway, so that the issue that came up here was that the defendant registered a caveat. The plaintiff applied to come and remove the caveat. So what the plaintiff required from the court was the removal of the caveat on the identified piece of land, as well as for the land to be registered by the registrar in the Lands and Deeds register, so that so that it could be a way of them being enabled to remove the caveat. So what was seen here was a possibility of fraud in the way the land was acquired by the party that claimed to have rights on it. And that brought about a question by the court. Equally, the validity of that entry that was put in the Lands and Deeds register. So ideally, what is entered is that transfer of land that is entered in the register. So the way that was done also was raising a question somehow. So what you see is that despite the law putting in these measures, how, or the process in which these things are done, the putting of a caveat, entering the land in the registry or the registered Lands and Deeds registry becomes questionable. It leaves room for fraud by any other person who is interested. This is why we keep seeing most of these cases coming up now and again. So what it actually brings out is that equitable mortgages are prone to abuse, especially when it comes to issues of fraud. There isn't enough security, or what you can say as security that would be sufficient when it comes to equitable mortgages. So anybody who has a claim on that land, or at least can show that has a claim on that land, can put a caveat. And then the battle comes in when the caveat has to be removed and it has to be mortgaged, or the land has to be mortgaged. This is why it becomes very important for one intending to get a mortgage, or indeed both parties, to carry out their due diligence to ensure that the land in question has no encumbrances. So briefly, those are the two cases. Anything? Council Sankalimba, how are you?
I'm okay, madam. Good morning. And how are you?
I'm fine, thank you. Did you take time to look at the Magic Carpets case?
No, I didn't even know that there was a case which was given.
Okay.
Sure.
So let's move on to the equitable rights of the mortgager. Remember, we talked about a mortgage being a contract and an interest in land. This gives you a dual nature of a mortgage. And noting that it is an interest in land, the implication is that there are certain rights that arise under this contract that is entered into. When you look at equity naturally tries to come out with a win-win situation on both parties, unlike common law. And if you look at the way equity is, equity will try by all means, or the nature of equity is that it upholds the rights of parties. So in this case, the mortgagor has rights as well as the mortgagee. So the mortgagor's rights, because those are the ones we're starting with, a mortgagor will have rights because of the proprietary interests that they have in that property, or indeed that they retain in the property. The rights that you come across or that pertain to a mortgagor are, first of all, the mortgagor will have the equity of redemption, or the equitable right to redeem. Last time we did talk about this, where at one point, if a borrower gets a loan, the loan has to be paid on the date that the parties have agreed upon, nothing before or after the agreement, because that will end up in disadvantaging the mortgagor. Now, when equity came in, equity gave the right to the mortgagor to pay at a certain date and to redeem their property, implying that you don't just lose out when you get a mortgage and it happens that the date for payment comes and you fail to pay, then you lose out like that. So that was cured in a way. So when you look at the equity of redemption, it remains a reality that the borrower remains the owner of the mortgaged land. So if the lender has rights that he enjoys on this particular property, this particular land, the rights can be properly distinguished. These are only rights of security and not the rights that would make them enjoy that particular property or the land as a tenant under an ordinary or lease, which would give them some beneficial rights. So it actually gives the right of the landlord to continue living in that particular property, which they have let to a tenant, and in normal circumstances would be looked at as being inconsistent with the tenant, because the tenant in this case is purported to have exclusive right or exclusive possession for the period that that lease is valid. But when the property is sold, it becomes different. If the property is sold and there is an increase in value, the borrower benefits from that. So we know the way markets work. In some cases, markets will fall and rise. So if it and when we talk about markets falling and rising, we are not talking about markets generally. Let's look at it in the context of property, the context of land. These days, for instance, where you can buy a 2-hectare plot, or yes, actually 2 hectares, and they will say that they want you to pay, depending on the area you're buying it from, net will cost you like $1,000, $500,000. In some areas, it depends if it is land on title, and where, like we have said earlier, the location, you probably buy it at 100 and something, and if you buy it at 130,000 or probably 165,000, that would probably be a small plot of 30 by 20. But what we are driving at is that there is a fall and a rise in value when it comes to property. And if there is any fall in value, it is the borrower who incurs the loss. So the borrower incurs the loss in a way because the borrower is entitled to the whole value of the property, which in most cases is subject only to the repayment of the loan. So now equity comes in to ensure that the borrower remains an effectual owner of the property. In this case, when we look at the borrower, we look at the borrower as having equity in the property, or more like having the equity of redemption. So this is basically the borrower having the rights in the property, and that property is subject to the obligations that are imposed on it by the contract that they have entered into between the borrower and the lender. So when you look at the rights of the mortgager, you see that the borrower has the equity in the property. The borrower has an equity of redemption. Are we together? Okay. So if you need to look at it from the common law and equitable point of view, you look at it from the part where equity intervened and created the equitable right to redeem, giving the mortgager the right to redeem the property, even after the legal redemption date had passed. Remember what we talked about from common law perspective, you have to pay on that date, nothing before or after. Yes. I think Hazel raised the hand.
Sorry, ma'am. I wanted to ask, is this right indefinite? How long does it stand for?
We remember last time we talked about within a reasonable period, and that will matter depending on the contract that the parties have entered into. We can place a definite date to reasonable, but it has to be within a reasonable period. So we have looked at the equitable right to redeem. Yes.
Yes, madam. Following what is just from asking.
Yes. You're following up on Hazel's question? Is that what you say, Danger?
From the courts, what is reasonable in terms? Can you go more than 2 years without paying, then you redeem your property, or it is just within maybe a period of 6 months? Because I don't know.
The best answer can come from cases, what has been the practice by the courts to putting a period to what is reasonable. Okay? So the best thing I can do is throw it back to you, since I've noticed that when you are given cases, you don't pay attention to them. You could do, you should research on a number of cases and what the courts have done, what type of judgments the courts have passed when it comes to equitable right to redeem. You can start from the case of Salt versus Marquess of Northampton. Salt versus Marquess of Northampton.
Yeah, come again, madam. Come again. I cannot get you.
Salt versus the Marquess of Northampton. And then you come down to the jurisdiction where we are. Okay? Are we together?
Yes, ma'am.
Okay, so Salt versus the Marquess of Northampton is an 1892 case, or in some books you find it written as 1891. So Salt versus Marquess of Northampton, 1892, SC1, SC1. You look at the reasoning in that case, and then you get down to our jurisdiction. Salt is SALT, SALT versus Marquess this is a title actually. It's MAR QUES. Salt versus Marquess of Northampton. Marquess is MARQUES, is OF. Northampton is NORTH. R T H A M P T O N. So, when it comes to the rights of the mortgagor, you come across the contractual right to redeem, what we have looked at as the equity of redemption. And you also come across the equitable right to redeem. The equitable right to redeem, which you usually come across as the equitable right to redeem. So I'm saying you come across a contractual right to redeem, or in some books you see it as the equity of redemption. It's the same thing. You also come across the equitable right to redeem. So the equitable right to redeem will just be termed as the equitable right to redeem. We have talked about the contractual right to redeem, the fact that this mortgage is a contract. We look at the equitable right to redeem. So we have established that equity actually allowed the mortgagor an equitable right to redeem on any date after that date that was fixed by the contract, that date of redemption that was fixed. So when you look at equity looks at this mortgage as merely being security for the money that is lent. And equity takes the stand that it is not right, or it is unfair or unjust that this mortgagor should lose his property because he was late in repaying the mortgage or late in repaying the loan. So what we see and equity coming up with, okay, what we see equity coming up with, or equity bringing, the mortgagee in this case is able to recover the money at a particular time. So what we see is a payment of the principal amount that was lent out or that was borrowed with interest, and an extra cost to it, which is paid even after the legal date of redemption has passed. And I think you can attest to it. That is the way that mortgages are done nowadays, where, or indeed loans, the longer you take, you even see, depending on the interest that you have agreed upon between the lender and the borrower, the interest rate will be somehow adjusted upwards, such that you are made to pay some money higher than what you were initially supposed to pay because of that delay. And the mortgagee gets to benefit from it anyway. And the one that suffers from it is the mortgagor. The issue being here, that in this context, the issue being that the mortgage, from an equity point of view or from the eyes of equity, is looked at as security for the loan. So we see a different perspective coming in with equity. What we also see is that the nature of a mortgage is now that there must always be a right to redeem. and the parties who put it as an express term of that particular agreement that they have entered into. So at the point at which they are negotiating or agreeing on the terms, this should be one of the terms that is put in that contract. The equitable right to redeem, and the parties must explicitly agree on it. This is why it is referred to, because it is an express term, is referred to as the legal right to redeem, because it is included in the contract. The parties expressly agree to it. It becomes a legal right to redeem. So I'll say this again, at common law, we see that this was different. When an express right like that was stated in the contract, the party had to obey that term strictly, paying on the debt that the parties had agreed upon. So if the parties, for instance, excuse me, in the mortgage, in the contract, agreed that the repayment will be on a certain day. Let's borrow the period that Councillor Sankalimba referred to, let's say after 6 months. Excuse me. The borrower will be expected at common law to repay on that date, not earlier, not later than that date. If there was any delay, you'd see forfeiture coming in, and the right to redeem would be lost. So like we said, this was a harsh stand. Therefore, the right to permit the borrower to repay at any stage upon reasonable notice to the lender. Again, we see reasonable notice coming in. The lender is given reasonable notice. The parties agree on the date that they will do the repayment. What would be determined to be reasonable between the parties would be agreed upon, and that would be done. In modern day practice, excuse me, I have a dry throat. I find myself coughing all of a sudden. So what we were getting towards that, we see the equitable right to redeem coming in. And because of this right coming in, the only way the borrower could lose the equitable right to redeem was if there was a delay in the payment, court proceedings were commenced, and the right was foreclosed. The lender in this case makes an application, and then the courts hear the matter, and then they rule that the property is foreclosed. Then we see these rights getting lost, or the lender in this case losing out because of the foreclosure. So foreclosure doesn't mean it is the end of it. There is a possibility, there was a possibility for foreclosure to be reopened. The borrower in this case would make an application to the courts showing that they are willing to make good any financial loss to the lender. Then the case would be reopened, and the matter is heard, and judgment is passed accordingly. We see that with equities intervention, the the debt that is fixed for repayment in the mortgage becomes a little more significant. And we see that this is a practice today where what happens between the lender and the borrower is that the mortgage agreement would provide a period of repayment, and the parties would agree to it, like we had earlier stated. In most practices, it will be an extended period of 3 months to 6 months, which can go further depending on what the parties have agreed. This is why when Councillor Sankalimba asked the question, it takes you back to what the parties agree on as what is reasonable. But you see that in most mortgage agreements, there will be a repayment after 3 or 6 months, or sometimes for the period that the loan was intended to last, or even a much longer period. And that's why I referred you back to the case law, starting with the case of Salt versus Marquess of Northampton. Start with that one. Research further on the practice in our jurisdiction. The periods will vary, the facts will matter. So all those things will come into play, the law, the facts. And you will see different judgments being passed. Council Sankalimba has got 2 gadgets. I see 2 angels here. Okay, so as you go on researching, you see that the practice keeps changing. We see that the terms of mortgages are becoming, like they're being changed to be better, to accommodate the parties of that are in this particular contract. And that is the practice that you come across nowadays. You go to get a mortgage from, a good example being National Building Society. The terms will be so many. They will give you every other detail which you have to understand and accept at the end of it. The periods will conform to, or the terms, most of the terms will conform to the equitable requirements as opposed to the common law requirements, because the law has been, or the practice has been growing to conform with the equitable requirements of a mortgage. So is there a question, any addition, any subtraction? So we have looked at the contractual right to redeem, the equitable right to redeem, and we can look at the equity of redemption. Are we together? Or better still, let's put it like this so that we don't get confused. Let's add to, I think we had looked at the equity of redemption earlier. Let's just add some more information on the equity of redemption. So when we talk about the equity of redemption, and the equitable right to redeem, we see that the equity of redemption represents the sum total of the mortgager's rights in equity. And when we talk about the sum total of the mortgager's rights in equity, we are referring to the rights in the property which has been brought forward to be mortgaged, or the right in the property which is subject to the mortgage. When we talk about the equity of redemption, we are also talking about the mortgager's rights of ownership in the property which is subject to the mortgage. And we are also looking at it from the perspective of an interest in land which can be dealt with like any other interest in that land. When we talk about the equity of redemption and the equitable right to redeem, okay, we're talking about two different things here. We're talking about the equity of redemption, and we're talking about we talk about the equitable right to redeem. We see that the two are different. So here is the difference. So we see that the latter does not exist until the legal date of redemption is passed. Whereas if we talk about the equity of redemption, we talk about the equity of redemption existing as soon as the mortgage is made, as soon as the parties enter into this contract to have this mortgage. So we are able to differentiate the two now, isn't it?
Please, may you come again, ma'am?
Okay. So the equity of redemption will exist as soon as the mortgage is made. Okay? When we talk about when we talk about the equitable right to redeem, we are saying that this will not exist until the legal date of redemption is passed. When you have the equitable right to redeem, the equitable right to redeem will only start to exist when you are supposed to pay your loan, for instance, today, and then somehow something happens, and then you haven't paid your loan, and somehow your lender brings in one or two things in line with, or probably says they will file for go to the court of law so that they possess your property. Being the owner of that property, you have the right to redeem the property at a date that you agreed upon as parties, on the terms that you agreed upon as parties. I hope it's clear. This is why I'm asking again if we have the difference between the equity of redemption and the equitable right to redeem.
Okay, but so I don't know, to get it properly. So the equity of redemption, it's more like a doctrine that is governing you once you enter into the mortgage. Then the equitable right of redemption is the action you take after the date has passed. Is that so?
We are going to hold that thought. Yes, Council Sankalimba, you want to say something?
I think what Lelo has just said, that is what I also thought, because maybe we we were supposed to arrange them in this manner. First, we start with the equity of redemption. Then second, we come to equitable rights to redeem, because equity of
Yes.
redemption starts when the mortgage starts. Then equitable rights to redeem comes after maybe you fail to pay.
Yes.
Yes, I think this is the way they were supposed to be arranged. So the
Yes.
first one is equity of redemption, then equitable rights to redeem comes second.
Yes. Yes.
Okay, thank you, madam.
Okay. So we are on the same page, all of us, which is a good thing. Okay. And okay, so we can go on to look at possession. Looking at possession. We've already established that the whole idea or the purpose of a mortgage is normally to provide security for the loan that is taken. So in an ideal situation, this loan is meant to finance the purchase of a property where this person who goes to this bank or this financial institution to get the money wants to leave. Of course, arguably, there may be so many reasons why people get these mortgages, especially now that people are becoming more and more commercial. But let's take the stand that in an ideal situation, a person will go to a bank, get, or a financial institution. These days, there are so many institutions offering mortgages to get this money to purchase a house and live in it. That's the stand we are taking. So what we see is that possession comes in this context. When we look at possession, it has been described by a number of scholars in different ways. We look at the description given by Herman J. in the case of Four Maids Limited. Herman is H-A-R-M-A-N. Herman is H-A-R-M-A-N. Herman J. in Four Maids Limited, in the case of Four Maids, for the number four in words, F-O-U-R. Maids is M-A-I-D-S. Limited Ltd versus Dudley Marshall Properties Limited, which is D-A-U-D-L-E-Y. Marshall, which is M-A-R-S-H-A-L-L. Properties Limited in brackets, 1979 in brackets, 1979. CH317. CH317 at 320. So In this case, Herman J. did describe possession, and in his description, he wrote, and I quote, "The right of the mortgagee, the right of the mortgagee to possession or to possession, whichever way you pronounce it, same word, the right of the mortgagee to possession in the absence of some contract, in the absence of some contract, has nothing to do with default, has nothing to do with default on the part of the mortgager, has nothing to do with default on the part of the mortgager, full stop. The mortgagee may go into possession. The mortgagee may go into possession before the ink is dry. Before the ink is dry on the mortgage, before the ink is dry on the mortgage, unless there is something in the contract, unless there is something in the contract, comma, express or by implication, comma, express or by implication, comma, whereby he has contracted himself out of that right. Contracted himself out of that right. Full stop. He has the right because he has a legal term of years. He has the right because he has a legal term of years in the property or its statutory equivalent. He has the right because he has a legal term of years in the property or its statutory equivalent. Full stop. And end of quote. Yes, Council Sankalimba.
Yes, madam.
Yes.
I'm having network problems. So from the time you started talking about the statement that you are giving out, I lost network. So I only got rights of a mortgagee in the absence of some contractors, something like that, and then I lost contact.
Okay, so I'll read it again. I'll start quoting. It says, the right of the mortgagee to possession in the absence of some contract has nothing to do with default on the part of the mortgager. The mortgagee may go into possession before the ink is dry on the mortgage unless there is something in the contract, comma, express or by implication, comma, whereby he has contracted himself out of that right. Full stop. He has the right because he has a legal term of years in the property or its statutory equivalent. He has the right because he has a legal term of years in the property or its statutory equivalent. Are we together? Okay. Let's look at another case that talked about possession. So I'll spell this one out. In the case of, you start writing as I spell, R-O, R-O, P-A-I, P-A-I, G-E-A, L-A-C-H, R-O-P-A-I-G-E-A-L-A-C-H versus Barclays Bank PLC, which is B-A-R-C-L-A-Y-S, Barclays Bank, B-A-N-K PLC, in brackets 1999, close brackets, 4 OER 235 did we get the case on the full citation? Thank you. So in this particular case, Clark, LJ, Clark is C-L-E-A-R-K, Clark LJ. Took the stand that it was correct. It was correct to consider that in the absence of a provision to the contrary in the mortgage, the mortgagee has a right of immediate possession. That's what Clark LJ considered in this particular case, that in the absence of a provision to the contrary in the mortgage, a mortgagee has a right of immediate possession. I hope we are together. Just indicates if we are together. Thank you. He also observed that, I'll quote his observation. He also observed that, I'm starting to quote, I suspect that many mortgagors would be astonished to discover that, a bank which had lent them money to buy a property for them to live in could take possession of it the next day. could take possession of it the next day. End of quote. So let's discuss these two statements. What do we learn about possession and when it comes to mortgages? The floor is open. I leave it to you. Just look at the thinking of these judges in these cases, and let's talk about it. What do we learn? We are open for your views. You can start with the first case and share our thoughts. I'm waiting for somebody to open the floor. Like Sina. Like Sina, what do you have to say? Council Richard. We took note of the two statements, isn't it? What do we understand? Let's make it interactive. So let me start this. In most cases, what do we notice when a party has taken out a mortgage to buy property that they are living in? The normal practice is that they will take the mortgage, buy the property, live in that particular property, and in an event that they default, and when we talk about default, we know that these payments that the parties have agreed upon that are given to the lender, the mortgagee now and again on the dates that the parties have agreed upon, and then they fail to honor them. We see that there will be, actually, in most cases, we don't even pay attention to what court cases are going on or the battle that is there on that particular property. In most cases, we just see a poster put, probably a property is on sale. The implication or what is behind that is that the bank or the lender or the mortgagee has repossessed the property. Now remember, the title holder is the mortgagor who bought the property, obtained whatever rights, title and rights, and what they do is probably in that particular contract, when they bought the property, went with to check with Ministry of Lands and everybody, as part of their due diligence, discovered that, well, it's okay to buy, no encumbrances. And then they hold the property for this period of 99 years or whatever lease they get into with the state. They will, or the assumption we take is that they will occupy that particular property for that period of time. And now they default on the payment of this mortgage. And the mortgagee comes in and says, well, here are the papers, we are repossessing. The actual possession is with the title holder, the one that bought the property. But the bank will come in and say, we are repossessing your property because you have failed to pay. And in some cases, depending on the agreement, we see the banks coming in and saying, well, we are going to take over your property and manage it until we get our money. In most cases, what we see is we're going to take over your property and sell it in order to get the money. I don't know about your experiences. But when you look at these cases of Formaids Limited versus Dudley Marshall Properties Limited, and then I don't know how to pronounce this, but I'm thinking a lot of words here are silent. So I'll just say it as Ropalach versus Barclays Bank Limited PLC. We see these cases having these observations made by these judges. So what we're saying is, what is our say on that? Has anybody read through and read through and read through, and they're starting to speak to them now? Let's start with the case of Formaids Limited versus Dudley Marshall. What is our say? The observations made by Herman J. He says that the right of the mortgagee to possession in the absence of some contract has nothing to do with default on the part of the mortgagor. The mortgagee may go into possession before the ink is dry on the mortgagee, on the mortgage, unless there is something in the contract, express or by implication, whereby he has contracted himself out of that right. He has the right because he has a legal term of years in the property or its statutory equivalent. What do we understand? That's what we want. I want us to discuss. Anybody?
Well, from what I understand, I think it's already written in the statement itself, is that the mortgagee is entitled to take possession of the mortgaged property unless there is anything contrary which states that they are not.
So in short, the parties must put it in their contract, right?
Mm-hmm.
That in clear terms, that if possession has to happen, this is how it should happen, because it shouldn't take one party to default for possession to take, like for the mortgagee, for instance, to come and say, because I gave you money on this, I have rights to it. And this is what we've been saying over and over again. I have rights to it. More like also claiming possession because they actually gave you the money for the particular property. So it should be set out from the onset. You shouldn't wait for the ink to dry, right? Because the mortgagee can come up and say, well, I do have rights in this particular property. So because I'm trying to protect as a way of security as well, I have rights to this property. And this is how we are going to go about it. It should be from the onset that the parties outrightly state the right of the mortgagee to possession and the right of the mortgagor to possession. We are saying that from the mortgagee's point of view, the mortgage is security for a loan. So rights for both parties should be clearly set out from the onset. And so the parties will know how the property will be possessed, and how they will go about their contract at any particular time. In some cases, like it is put, it shouldn't take a default for possession to happen. Yes, Lexina, you have a comment, a question, an addition. Please go ahead.
Comment on the question. A neighbor of ours in our residential place had something similar to what we're discussing this morning. And what happened was they had a mortgage with the bank, and after they defaulted, the bank repossessed their house and their cars, and something like that. But then the bank went ahead and brought down the entire structures. Like there was a main house and 2 servants' quarters on the premises, and they brought down everything on that property, and the residents were ousted out of the premises. Now, my question is, in a scenario like the one I have just explained, and I am the person that did the mortgage, how do I redeem my property if the bank brings my property down?
There's always a value to it. There's the monetary value. So the fact that they didn't only get the land, they went on to get the vehicles and everything. They assessed, they knew the value of that property. They assessed the property again and probably came up with the fact that the value had gone down. Remember, we're talking about value appreciating and depreciating. So they must have seen a depreciation. Therefore, getting the vehicles and probably selling them would give them the value that they required. You do have your equitable right to redeem. It's not taken away from you. That's a legal right that you have, and they'll base it on the value that you need to be given back. I hope I've answered your question. Are we together, Alexina? Have I responded? Okay, thank you. So anyway, parties must ensure to put provisions in the contracts to indicate how possession will take place. Whatever happens along the life of this particular contract. But like I earlier alluded to, that is if you look at these cases. But like I earlier alluded to, in practice, you see that mortgages will, the mortgagee will not take possession in most cases until there is a default from the mortgager. And they will take over the property, they will exercise their right to sell, similar to what Lexina has just told us. And in some cases, you find that they will possess and just hold on to the property and its value. In some cases, they will possess and will sell it to the next buyer to recover their money and continue with their business. I hope we are together. So when you look at what equity does when it comes to protecting mortgagors, you see that it goes further than the right to redeem. You see that when this agreement is entered into and these rights are acquired, you find that that property, if it is mortgaged to a particular person, will be protected from certain bargains that will be might probably be entered into by a party. So you see that when these properties are obtained by, let's say, the mortgager and the mortgagee get into this contract to have this mortgage. And when you look at the terms that they have agreed upon, there's very little legal advice that went into it. Equity comes in. It will not permit such type of a contract to go ahead, because this is a legal contract. It has to be based on those principles. The legalities have to be in it. So whenever such contracts are entered into by parties, there must be adequate or informed legal advice. So the fact that the law will not allow such a contract to be made offers protection to the mortgager. So in some cases, you find that there is a husband and a wife who differ, and one party wants to go ahead and mortgage the property or do something to that particular property. You see that the legal aspects come in, and that party, if you look at it from an equitable point of view, will be stopped from probably getting or agreeing to that lease, bringing in this agent to do whatever types of transactions that should be done on that particular property. So usually the courts will look at the facts, will look at the contract, and probably set such a case aside. And we can say that that is a form of protection that is given to a mortgager. When you look at the terms, again, if they're too extreme, or indeed they show some feebleness in terms of reasoning of the parties, the courts will pay or take heed of all such things. So it is just right that proper legal advice should be given, contracts are entered into in a proper way, and not to infringe on the rights of either party. You can refer to the case of Credit Lyon Bank Netherlands versus Birch, which is CR Credit CREDIT. CREDIT. LY, this is one word, Credit and Lyon, LYONN, LYONN, AIS, Bank, Bank, Netherlands is NEDERLAND. NEDERLAND versus Birch, which is BURCH. BURCH. In brackets 1997. In brackets 1997. close brackets, 1 OER 144. Are we together? Are we together? Can I get a response? Is there somebody who is behind?
We're together, ma'am.
Hazel, can you say that again?
We're together.
Thank you. So, in this case, in an employment setting, anyway, a junior employee was granted a mortgage, and they were terms that were the court did not agree with. And in their view, the court stated that they were shocked, or indeed the terms that the parties that had come up with shocked the conscience of the court. These are what we are talking about generally is unconscionable bargains and collateral advantages of mortgages. So we see that in the case of Credit Leon, the court stated that the mortgage that was granted by a junior employee of her employer's debts had a term that was unlimited in time and amount. And so in expressing their view, the court stated that it shocked their conscience. So basically, if I have to just quote the short sentence, it said, shocked the conscience of the courts. Can put it in, because those are the court's words. It shocked the conscience of the courts that if, according to them, if it had been challenged on that basis, it would almost certainly have been held to have been an unconscionable bargain. So according to them, the transaction, this mortgage transaction was extreme. It was extreme, amounting to this shock. They further stated that, and I quote, I'm quoting, an independent solicitor would certainly have advised her as strongly as he could that she should in no circumstance enter into the mortgage. An independent solicitor would certainly have advised her as strongly as he could that she should in no circumstances enter into the mortgage. So when this, that was the end of the courts, by the way, when I read out that she should in no circumstances enter into the mortgage. End of quote. When you remember, this is a contract that the parties are getting into, and we know that when you look at them, it is entered into freely and voluntarily. The terms, we're focusing on the terms here. The terms should not be terms that are going to be unfair to one party, that are going to be oppressive to another party, that are going to be harsh, that are going to be, name them, there are so many negative words that you could use. The terms should be terms that are fair to both parties when a mortgage is entered into. Hence the shock that the court got after looking at the terms of this particular contract. So when it happens that the mortgage or a particular transaction that the parties have entered into, in this case, we're talking about the borrower and lender, the mortgager and the mortgagee, what could be desired is that the contract is set aside as one that is lacks conscious and conscionable. So it is a bargain that hasn't got that consciousness to it. So in short, it shouldn't be a bargain that is extreme that the parties should enter into. When it is shown that it is like that, of course, there should be one of the parties in that particular contract that impose these terms on the other. So, and in most cases, you find that they go to affect the conscience of the other party. Therefore, the courts will opt to set such a bargain aside. Is it clear?
Yes, ma'am.
Do you have an argument against that? And adults who can enter into contracts, allowed to enter into contracts? Isn't a party who buys a house and decides to sell it free to do so? Let's take an example of what is happening in Zambia these days. Do we know Kalingalinga, the compound Kalingalinga? Do we know about it? Or have we been to that area of Lusaka?
No.
Say again?
No.
Okay, but have we noticed the rate at which houses are being sold in Lusaka, especially in low density areas?
Yes.
You can imagine that there are two parties involved there. There is a seller and a buyer. And these people enter into this agreement, right? To sell that particular property at a certain price. And the transaction goes on. Would it matter if that transaction is seriously disadvantageous or indeed commercially misguided, such that it renders one party losers? Because when you look at it critically, most of those people that sell that property are different from the people that you probably find in places like Woodlands, Kabulonga. Their exposure is different. Arguably, their level of education could also be different from them. And there's a high chance that they didn't get that property. They are not the first owners of that property. Maybe it passed on generations, and so they don't see the value of it as probably a person who bought a house in Kabulonga would see the value of it. This is just for argument's sake, right? So now if a transaction passes between the parties, or if they enter into a transaction and it happens to be seriously disadvantageous or commercially misguided, should the law surely take a stand when the parties are adults who agreed to get into this lawful contract and the transaction was done? What is our view?
Okay. I would say that even though the law isn't always fair, it should be just. And when we take in the factors of, one of the qualities of contracts is that it should be expressly implied, terms should be expressly implied, be easy to understand, to read, such and such. So taking into account some people's level of education and inability to understand the terms which have been stated, maybe because of the language, the jargon, I would say then the law should be able to take that into consideration.
Yeah. Thank you for that contribution. Lelo and Richard, what do we say? Here is a landowner who has the liberty to get into that particular contract, make that bargain, get his money, goes wherever he goes, we don't care. And here is a buyer who buys this property and makes good of it and makes probably supernormal profit. Should the law then have a say? Should Equity come and say, well, no, let the contract be just? We have Hazel's view, right? So Lelo and Richard, anything? Okay, Lelo has nothing to say. Okay, so in actual sense, and if you look at a few more cases, you discover this, that the law doesn't take the liberty that every man has to enter into such bargains away, or indeed to possess or dispossess of their property as they wish. That remains as a right that the property owner has all the liberty that they have. Of course, different cases will present you with different ways of thinking depending on the facts, and they will apply the law accordingly. But that is one of the things that you should put in mind. So the bottom line, therefore, is that you can, the courts will definitely take a stand against unconscionable bargains, and also because of their unfairness, the disadvantages they present, sometimes involving fraud, forgery, and all those things. So the law will definitely take a stand. But again, depending on the extent, it will not take away the liberty of any man to get into such bargains or indeed dispose of their property as they wish. So if you enter into a mortgage and the mortgage is of such a nature, there's a high chance that the court will render it void or uphold it, depending on the case, the circumstances. This is why you see people getting into loans that are so unfair, so high, the interest rates to buy property, but they still get into it. It may be unreasonable, yes, but not unconscionable. So the courts will still let it hold. Here's where you have a question.
Okay. I wanted to ask, for argument's sake, let's say I do get into a contract which terms are extreme and such. What would the argument be in court? What would the defense be?
Mostly if it's unconscionable, yes, it would hold. Unreasonable, you agreed to it. So usually it's on a 50-50 chance unless you argue it properly, whatever your facts would be. But if it goes to, remember the expression we looked at, we started with earlier, one that shocks the conscience of the courts. You would challenge it on that basis, the unconscionable parts. It being a reasonable, unreasonable, that could be a bit difficult because of the liberty that you have or the rights that you have as an adult. Okay, we can wrap up this lesson for today, and we'll continue with mortgages. I'm sure we'll wind up on this, looking at collateral advantages, and we'll also look at the rights of the mortgagee. Since we're still looking at the rights of the mortgager, we continue with the rights of the mortgagee. Read the cases that you have been given in detail. It will also make you understand that whenever the redemption comes in, the redemption must be free from any what they call cloaks and fetters. And as you go on with one of the cases, as you read through, you'll be able to see how the cloaks and fetters come in. Okay? So thank you very much. I've noticed that we have ended with a very small number, and the network today seems to be very poor. I'll see you. We have got 2 hours which we need to catch up on. Lelo and I will communicate. And Lelo, if I don't respond, you need to forgive me. Sometimes I think I have and I just forget. See you next time. Thank you very much.
Thank you.